The fundamental question the Supreme Court was asked to decide in Atchison Hotels LLC versus Laufer was standing. Did Ms. Laufer have standing to sue Atchison Hotels? The Free Legal Dictionary defines standing as, sometimes referred to as standing to sue, is the name of the federal law doctrine that focuses on whether a prospective plaintiff can show that some personal legal interest has been invaded by the defendant. It is not enough that a person is merely interested as a member of the general public in the resolution of the dispute. The person must have a personal stake in the outcome of the controversy. A person cannot sue simply because they see something wrong. They have to have a personal stake in the issue at hand, which brings us to the opinion in this case. Deborah Laufer has sued hundreds of hotels whose websites failed to state whether they have rooms accessible to the disabled. As the sheer number of lawsuits suggests, she does not focus her efforts on hotels where she has had any thought of staying, much less booking a room. Instead, Laufer systematically searches the web to find hotels that fail to provide accessibility information and sues to force compliance with the Americans with Disabilities Act. Now, ordinarily, the hotels settle her claims and pay her attorney's fees, but some have resisted, arguing that Laufer is not injured by the absence of information about rooms she has no plan to reserve. Only plaintiffs who allege a concrete injury have standing to sue in federal court. Laufer, these hotels have argued, is suing to enforce the law rather than to remedy her own harms. It appears rather obvious that Ms. Laufer had no intention to book rooms at most of these hotels, or any at all. As Justice Barrett, who wrote the opinion, noted, it seems Ms. Laufer was looking to force hotels to comply with the Americans with Disabilities Act. In other words, Ms. Laufer was acting as a federal vigilante, and quite a prolific one at that. Laufer has single-handedly generated a circuit split. The Second, Fifth, and 10th Circuits have held that she lacks standing. The First, Fourth, and 11th Circuits have held that she has it. We took this case from the First Circuit to resolve the split. In fact, Ms. Laufer has brought so many suits in so many jurisdictions, she has created her own circuit split regarding her standing.